Phil, the first one I want to talk about today is there was a case in 2022 called Thryv, and that's a company, Thryv Inc, Thryv. And under Thryv, the board expanded the legal concept of what are called make whole remedies under the National Labor Relations Act for employees who are victims of an employer's unfair labor practice charges. Previously, prior to Thryv, those remedies were typically limited only to back pay and reinstatement. Under that Thryv decision, the board expanded relief that it ordered employers to pay when they violated the National Labor Relations Act. And those wider range of damages, but beyond the lost back pay and benefits and then reinstatement, included medical costs, credit and debt expense, job search expenses, moving expenses, and potentially tax consequences. And this marked a big change for the NLRB on the relief that they could issue against employers. There were some subsequent legal developments. In May 2024, the Fifth Circuit Court of Appeals partially vacated the NLRB's order in that Thryv case. However, the court did not outright reject the NLRB's expanded view of those remedies. There has developed a circuit court split. Not surprisingly, the Ninth Circuit ruled that the broader Thryv remedies are within the NLRB's authority. And so now there's a split in the circuits. The Third Circuit, like the Fifth Circuit, ruled that the board have limited power to impose certain types of consequential damages. Well, just in the last couple of days here, the NLRB, the Ninth Circuit Court of Appeals, reviewed another one of these Thryv cases, and it was a split panel decision from the Ninth Circuit Court of Appeals. And the Ninth Circuit Court of Appeals held that the NLRB is allowed to make employers pay for financial hits that workers take as a result of an employer's unfair labor practices, because doing so makes the employee whole under the National Labor Relations Act. And so the reason why I'm sharing this with people is that it used to be, prior to Thryv, that the employer's monetary exposure was very, very limited.
Yeah, just relatively back pay. Now there's a lot of other consequential pay associated to that.
That's right. And the reason I'm sharing this with everyone is to put it on people's radar that I think this one's heading to the U.S. Supreme Court for eventual determination, given the split in the circuit. So keep your eyes on that one.
Yeah, absolutely. We'll stay tuned for an update.
I want to shift gears, talk a little bit about a recent decision from a Mississippi federal court that came out yesterday, actually. And in this decision, a federal judge struck down a Biden-era U.S. Department of Health and Human Services rule that protected gender-affirming care under the Affordable Care Act. That court ruled that federal officials at the Department of Health and Human Services exceeded their authority by broadening the definition of sex discrimination to include gender identity. So in that order, the district judge stated that he was bound by the 1970s definition of sex discrimination. And so this ruling is significant. It comes after 14 Tennessee and 14 other states sued the Biden administration in Mississippi federal court last year, accusing the Health and Human Services of attempting to enshrine sweeping gender identity mandates without congressional consent. So again, I think this one may also be heading for eventual determination, and does show sort of a trend going on around the country on these types of issues.
So, Burt, on that one, are they saying that that is not a protected class?
That's exactly right.
We're breaking it down to? Okay.
Yes, that under the laws of the federal government, in particular the laws that apply to the Affordable Care Act, that gender discrimination or gender identity is not a protected status under those laws. It does not mean, of course, that gender identity is still well. Let me phrase it a different way. Gender identity is still a protected status under Title VII, as the Supreme Court ruled several years ago. But it remains to be seen whether the Supreme Court might revisit that one at some point as well.
Okay, very good. What else you got for us, Bert?
Yeah, and the last one I want to talk about for everybody is just a reminder, especially for our Illinois listeners. I'm seeing a bit of a resurgence in personnel file requests in many instances where employees request access to their personnel file. In Missouri, employees have no right to access their personnel files. Those belong to the employer, not the employee, and the employees do not have a right to access those. Illinois is very different. They have a personnel file access law in Illinois that gives employees the right to access their personnel file upon reasonable notice, and the employers have to provide a reasonable time and a reasonable place for the employees to inspect their personnel files. In addition, in Illinois, if the employee sees something in their personnel file that they want to comment on, they have a right to include something in the personnel file that addresses whatever it is that's in the personnel file that they take issue with. And so there are a number of states, I think there's 19 states to be exact, that provide current and former employees with access to their personnel files upon request. Many of those states' laws define personnel file to include information and records related to performance, discipline, and termination of employment. And so I really just want to raise this as a reminder to employers that employees in many of the states, Illinois included, have this right. And so you do need to, from time to time, audit the personnel files, or at least audit the requirements within the business of what should and should not be contained in a personnel file. Make sure that it's complete, make sure that it's accurate, make sure that it's in proper form, that if you want to use something in litigation down the road, that it's contained in the personnel file. You don't want to get caught not having the proper documents in the personnel file, because that could possibly later preclude you from using those documents in defense of a case. And so again, I just want to raise it as a reminder to employers, the importance of the personnel file.
So back in my day in human resource management, then the debate was, what is a personnel file, right? My file in my desk drawer of the 15 people who report to me versus the file in HR that has all of the employment records and employment history data in it as well. Any thoughts on that, Bert?
Yeah, the one that I see most frequently, Phil, is oftentimes a manager has a manager's file on an employee or particular employee.
These are my notes, right?
Yeah.
That's what. Yeah, these are for me. These are my notes.
Yeah, and those are the ones you want to be really, really careful about, because sometimes there may be inappropriate things that are in those notes that you don't want to come out in subsequent litigation. Other times there's great information in those documents that you do want to come out in subsequent litigation. And if those documents are not included in that personnel file when the employee reviews it, or when the employee makes a request for that personnel file post-employment, you run the risk that you're going to be precluded from using those documents down the road. And so again, that's why you want to educate your managers, your supervisors, to make sure that they are including all relevant and pertinent information in the personnel file, that it's being maintained in there properly. And so again, it serves as a reminder. Some of these things, it gets so complicated these days with all of the laws that we have to pay attention to and all of the requirements at the federal level and at the state level, that we sort of forget some of these basics. I'm just urging employers to go back and take a review, make sure that you are from time to time taking a look and auditing what you require to be included or what you exclude from personnel files.
Yeah, no, that it's so simple on the surface, right? My personnel file, then you get into the manager's desk file. The manager has a set of files at home because he can't or she can't lock the desk. Then I have my manager's text messages to the employee. I mean, it's not as simple on the surface as we would like for it to be,
Exactly.
particularly with technology today. Yeah.
That's exactly right.
Yeah.
Facing complex employment law challenges? As an AIM member, you get direct access to Ogletree Deakins' top attorneys for expert guidance and defense. Call AIM at 800-948-5700 or visit aimea.org to engage expert workplace specialists today.